Your Honor, at this time, the defense would like to file two motions. I have provided copies of both of them to the state. We have a general demurrer and a motion to dismiss. A motion for directed verdict of acquittal. With the court's permission, I'd like to file those in open court.
Yes, you may. And I'll get a clerk up here to receive
it.
it.
Copy for Your Honor.
Thank you. I will take those. And let me get it. I got a clerk en route to have those documents filed in open court, but I do thank you very much for the courtesy copy.
That's a good point. Sorry, Your Honor. Mr. Petrie has made a good point that his motion should go precede mine, so I'm going to go with that.
No problem.
The only reason that, depending on the court's ruling, it might have shortened what else we got to do.
No, I understand, Mr. Petrie. No, not a problem, Mr. Petrie.
So do we need a clerk for me to start?
No, not for you.
Okay. Your Honor, I'm going to move the court to strike the testimony of Mr. Fryman, F-R-E-Y-M-A-N, from the FBI. The state stated in open court that it would link up the chain of custody for the evidence that was analyzed by Mr. Fryman, and here's what we've got. What we've got is that sometime in February or March, 2011, the cell phone belonging to Andrea Sneiderman was turned over to somebody in the district attorney's office. At some time later, Mr. Potter recovered a BlackBerry identified as having been Mrs. Sneiderman's from the office of Mr. Pasiti. Where that cell phone had been prior to Mr. Potter getting it, we have to assume, Your Honor, and you just can't do that. Where it had been prior to Mr. Fryman getting it back from Quantico or wherever it been cannot be assumed. So here's what we've got. Mr. Fryman, Your Honor, says he has never, to his recollection, ever seen a physical BlackBerry in this case. What he saw was a disc identified to him as being a mirror image of the BlackBerry. Granted that a BlackBerry itself with a serial number and identifying markings is not really in and of itself a fungible item. It's distinct. Mine can be distinguished from somebody else's. He's never seen that. And we're not actually talking about the physical carcass of the BlackBerry. What we're talking about is the data that is removed from it. There is an absolute dearth of evidence before this court, Your Honor, for this court to determine that the image that Mr. Fryman testified that he examined was, in fact, imaged properly. Now, he says he makes assumptions that it's done the proper way. We have procedures. I think he said it's industry standards, which may well be. Whether or not that was done in this case, when he examined this image, he has no idea where that BlackBerry had been. He has no idea from the time that that it was sent from the local FBI up to the lab in Virginia. He has absolutely no idea what happened to it. Was any of the data manipulated? Had it been manipulated between the time that Mr. Kirschenbaum left it with the district attorney's office? We don't know. And in this case, Your Honor, they have to show that not only is there a chain of custody, but this isn't like a gun. It's not like a box of something that you can look at and tell whether or not it's been manipulated or been used. This is the internal guts of a computer, in essence. I mean, the BlackBerry is, in actuality, it's a computer. And there must be a showing on the part of the state, Your Honor, that what Mr. Fryman examined, for instance, the image that he examined is, in fact, an accurate image of the BlackBerry that the state says Mrs. Sneiderman had back on November the 18th through January the 5th of 2000, November the 18th, 2010 through January the 5th, 2011. They can't do that. They haven't done that. I objected. The state said, Judge, we'll link it up. Well, they didn't link it up, Your Honor, and I asked the court at this time, based on the simple rules of due process and the rules of chain of custody, to tell this jury that you order them to strike the testimony of Mr. Fryman in its entirety. He has nothing whatsoever to add to this jury that has been linked up through other documentation, other witnesses saying that what he thinks he looked at was in fact what he looked at, and more damaging, Your Honor, is he cannot establish that there was no damage to the BlackBerry, no other manipulation, no other erasures, no other additions to that BlackBerry other than what he himself did. Now, he himself said he didn't do it. I'm not suggesting that he did, but he doesn't know what happened to that BlackBerry when it wasn't in his possession, and he said it was never in his possession. So, Your Honor, I do believe that the state has failed miserably in establishing a chain of custody for the image that he examined, and that should be no part of this jury's consideration.
All right, thank you, Mr. Petrie. Ms. Cross, you may address that issue.
Thank you, Your
Because
Honor.
I do recall, I think you told me here in court you were going to link that up later, so.
I did, Your Honor. I believe the state's done that to the satisfaction of the law. The case I'm referring to is Johnson versus the state. It's 271 Georgia, 375. It's a 1995.
I'm sorry, 375?
375, Your Honor.
Yes, ma'am. I have Ms. Jeffries pull that.
Thank you.
If you have a copy, I'll look at your copy while she's pulling
I
it.
do. It is, the relevant portion is highlighted, but for Mr. Petrie's purposes, it is enumeration 13.
All right.
Just one moment, Your Honor.
Oh, you may.
Closer to my eyeballs.
That's fine. That was 271 Georgia, 375, Ms. Jeffries. Johnson v. State.
If I said Georgia appeals, Your Honor, I meant Georgia. It's a Georgia Supreme Court case. And if I could hand it up.
You may approach. Yes, ma'am.
Thank you.
Thank you.
Thank you. The state need not show every single step in the chain of custody to establish a valid chain of custody for any particular piece of evidence. What the weight and the testimony was is that the defendant, by stipulation, had a phone number 404-374-1931. Those phone records were stipulated into evidence. Testimony was that the defendant's attorney turned that device, a BlackBerry device, over to the state in either February or March 2011. That Mr. Potter's testimony was that he retrieved it from the place that it would be normally kept in the district attorney's office in a box that had that is designed and specific to electronic devices. That at the time he transported it to the FBI office, that he documented that fact. The testimony from Agent Fryman was that he attempted to, or there was an attempt to get into the BlackBerry device, but because it was password protected, had to be sent off. Someone else, a civilian lab technician, made an image of the BlackBerry device, and it was Agent Fryman who examined that image. The state need not show every step of the chain of custody to establish what was indisputable in this case, that the defendant's BlackBerry 404-374-1931 was in the defendant's possession. There was testimony that it was in her possession as late as January 5th, 2011, that then was turned over to the state, the district attorney's office. From the state, it went to the FBI. From the FBI, an image was created, and the opinion of the expert is the opinion of the expert. The state need not show everyone who touched the item. The state need not even enter the item. The chain of custody or any deficiencies the defense alleges therein will only go to the weight that the evidence is afforded, not its general admissibility, and the state has established a sufficient chain of custody to permit the admissibility of the evidence. So that's the state's position. We rely on Johnson versus the state. We need not show every person who touched it, need not even enter the device. Just sufficient to absent any affirmative evidence of tampering, and there certainly has been none. No evidence of tampering with this device at all. Absent that, the state's chain of custody is sufficient. We'd ask that you deny the defense motion.
What, Ms. Cross, what evidence item was that? Wasn't there an evidence sheet or something connected with this BlackBerry?
Yes, Your Honor.
What number? May I see that, Kelly Carpenter? You can.
Exhibit number 95.
Let me take a look at that. And Mr. Petrie, this was an evidence?
Yes, sir.
Okay. I'm gonna hear from you in a minute, Mr.
Yes,
Petrie.
sir.
Let me just take a look at this. Yes, Kelly, we're back on the record. Yes, ma'am.
Just refer Your Honor to the facts of the Johnson case that I provided to the court. In that case, it was an issue about the defendant, in that case's blood that was drawn. And the challenge from the defense was, well, hey, you didn't have the person who drew the blood. You didn't have anybody who put it in the vial. You didn't have anybody who maintained the contact with the facts in that case were the vial of the blood before it went to the lab and the GBI performed whatever test they performed on it at that time. Similarly, Your Honor, and the Supreme Court of Georgia said, no, you need not do that. Absent some sort of affirmative evidence of tampering, the state need not show every step. In that case, they didn't show the person who pulled the vial of blood or obtained it from the defendant's jacket. What they did do was present the testimony of the expert that based upon the evidence that he or she was satisfied with the procedures that had been followed, that it appeared to be a sample of integrity, and based on that, the expert gave its opinion. Anything beyond that just goes to the weight of the evidence, not its general admissibility. So we'd ask that you deny the motion.
All right. Mr. Speaker, you have the last word on that issue.
Thank you, Your Honor. Here's where the state's analysis is defective. In the Johnson case, what you've got is a vial of blood that is labeled and says, here is blood from person so-and-so, drawn by person so-and-so. The actual person who drew it is not here. That blood is analyzed, and the witness testified as to the analysis of the blood. That ain't what we've got here. What we've got here is a BlackBerry is taken from the defense attorney by the district attorney's office. We don't know who to. We don't have a vial of blood or a BlackBerry that came back to Mr. Fryman saying, this is the vial of blood, this is the BlackBerry taken by so-and-so on such and such a date. Here it is, Mr. Fryman, do your job. Mr. Fryman is given a disc, a copy of what purports to be
a mirror image.
A mirror image that has to be done under proper laboratory procedures. It has to be done by a qualified expert. It has to be done under very sanitized procedures, you heard. And he says that that's their normal procedure to do that. But it's not like he's getting that vial of blood back and it still says it's Andrea Sneiderman's blood. He is getting a mirror image back, Your Honor. My objection gave the state every opportunity to link up this chain of custody. Chain of custody is not anything unique to this mirror image, to this BlackBerry. They knew coming in, they've got to show that what the evidence is, they say is evidence against Mrs. Sneiderman, is in fact evidence that this jury can rely on. And what I'm suggesting to this court is they have just failed to do that. They have shown that Mr. Fryman looked at a disc. He made an analysis of that disc, and he quite frankly doesn't remember much of what he found on that disc, but that would go to the weight, not the admissibility. But how that disc was made, were there any glitches? Anything like that, we don't know, Your Honor. And Mrs. Cross is right that the mere possibility that there is a tampering is not sufficient. And they don't have to shore up every deficiency in the chain. If the FedEx guy that delivered it's not here, that's no big deal. But what you've got is there was actually significant critical testing done of that BlackBerry that we don't have any opportunity to cross-examine those people about, Your Honor, under the way the state's trying to introduce this evidence. That's fundamentally unfair to Mrs. Sneiderman. Mr. Fisher, who supposedly did this testing, is on the state's list of witnesses. He's available. He is available at the telephone number that they gave us because I talked to him, and they didn't bring him. And that is a defect that they were given the opportunity. They were put on notice that we were objecting to this. They didn't link it up, and we would ask the court to disallow this testimony.
All right, thank you, Mr. Speaker. 1 second, lawyer.
Jeff Hullinger back with attorney Tom Beaver. Tom, explain to me what's been going on here and what we should look for.
Well, right now, first of all, the prosecution, the state has rested its case.
Surprised by that?
Somewhat, because it was predicted that it would be going longer by another week or two. So it's quite a bit shorter than was thought. This then puts you in the stage where there's a motion, there are motions in front of the court to essentially dismiss the case either, or right now, there is a motion in front of the court to strike the testimony of one of the FBI agents who testified about evidence from the Sneiderman cell phone. And the basis for that motion is an alleged improper chain of custody having to do with the cell phone and the image taken from the cell phone, the BlackBerry, that image being a copy of the BlackBerry. And what the defense is saying is that the state failed to put up
It is a close call.
that chain of
However, at
custody.
this point
All right,
in
back
time,
to Judge Adams right now.
Your motion is for us to strike Mr. Fryman's testimony and indicate that at this point in time, the chain was established. It's close. However, I'm going to let it go forward at this point in time, but I would deny the motion.
Thank you.
All right. With that said, I'm going to direct the state to prepare a proposed order indicating that I'm denying that motion for removal of Mr. Fryman's testimony and that a sufficient amount of evidence was presented for the case to proceed on chain of custody.
Yes, sir.
Let's see. Mr. Chalmers, I do have a clerk, and Ms. Marvel is here, so those items can be filed in open court. Ms. Marvel, it may have been set over there, various motions of general demur, a motion to dismiss, and a motion for a directed verdict of acquittal. It has been filed by the defense. If you could have those indicated they were filed here in open court, stamp them, date them, and have them filed appropriately. Mr. Chalmers, you may proceed, sir.
Thank you, Your Honor. May it please the Court, Your Honor. What I thought we would do is argue first the general demur, and then move on to the motion for direct verdict of acquittal. As per the Court's instructions, I will keep this brief as possible. The first issue, Your Honor, is the general demur applies to counts 1, 2, 3, 5, 8, and 10. That is the hindering count, which is count 1. Count 2, which is the concealment of facts rather than material facts. Counts 3, 5, 8, and 10, which are false statement counts. Your Honor, in the Henderson v. Hames decision, the Supreme Court decided unanimously a couple years ago that an indictment that fails to allege all the essential elements of a crime is void and of no force and effect, and therefore it's appropriate to grant a general demur. The indictment that was filed by the state in this case, which was, of course, the third indictment that was filed against our client, has a number of essential elements not alleged. And we'll skip right to count number 1 if we could. Mr. Williams, can you put up the PowerPoint if you would?
You want me to lower the screen back? I can put it back up.
Yes.
Okay. Not a problem.
Your Honor, this is the statute that the state has attempted to charge our client with a crime on. It's 1610-50 of the Georgia Code. A person commits the offense of hindering the apprehension or punishment of a criminal when, with the intention to hinder the apprehension or punishment of a person whom he knows or has reasonable grounds to believe has committed a felony or to be an escaped inmate or prisoner, he harbors or conceals such person or conceals or destroys evidence of the crime. The relevant portions for our argument are underlined, Your Honor. The state is not proceeding on the basis of subsection number 1, harboring and concealing a person. They are proceeding on the basis of subsection 2. The brief that we have filed, Your Honor, outlines the elements of this particular offense. According to the Court of Appeals, the state must allege and prove that the defendant knew or had reasonable grounds to believe that Hemi Newman had committed a felony. Must prove or allege and prove that the defendant concealed or destroyed evidence of that felony through specific acts. Third, that the defendant did so with the intention of hindering the apprehension of Hemi Newman. Our first ground, sir, for the general demur is that the indictment fails to allege intent. Can you please, Mr. Williams, move to the section of the brief? I think it's the next page of the PowerPoint. Actually, that's the standard for intent. Would you please move one forward? One more. Count 1. I'm sorry, it's a little bit small, but count 1 alleges with the offense, or charges defendant, Andrea Sneiderman, with the offense of hindering the apprehension of a criminal in violation of the statute, in that said person did knowingly and willfully conceal facts and destroy evidence of Hemi Newman's guilt in the murder of Russell Sneiderman, which she knew was evidence of the crime of murder. I won't read the entire thing because your court can see it, Your Honor can see it. The word intent appears nowhere in that allegation. Nowhere in that allegation or in that count is it alleged that the defendant acted with the intent to hinder the apprehension of Hemi Newman. In the absence of that essential element, based on the Supreme Court's decision in Henderson v. Hames, the allegation is void and subject to a general demurrer. The second problem with the count, Your Honor, is that it fails to allege that the defendant knew or had reason to know of Mr. Newman's status as a felon. The only mens rea that is alleged is that she did knowingly and willfully conceal facts and destroy evidence, and that she knew evidence was of the crime of murder. It's entirely unclear from looking, Your Honor, at the indictment if the which she knew evidence was of the crime of murder refers to the concealing facts prong or the destroying evidence prong. It looks to me very clearly, though, that it was designed to be the latter, and in any event, the grand jury could have been easily very confused by that. We'll get to that point in just one second. But nowhere in here does it allege that Mrs. Sneiderman knew or had reason to believe that Hemi Newman was involved in her husband's murder. Second element of the offense, which was in fact missing. Third, Your Honor, it is not, please go back to there. Mr. Williams? Okay. The third problem with this particular count is that it alleges that the defendant concealed facts and destroyed evidence. It is not a crime in Georgia to conceal facts. It is a crime to conceal evidence if and only if all the other elements of the offense are met. The grand jury very easily could have been confused by this into believing that the concealment of facts stated a violation of this statute, and the count is defective for that reason as well. The fourth thing, Your Honor, is that if you look down a little bit below, where we get down to the specific things that the defendant is allegedly supposed to have concealed, the first one relates to destroying text messages and a record of telephone calls. That presumably is the destruction. As you can see, it's destroyed text messages and record of telephone calls. We'll get to in the directed verdict of acquittal, Your Honor, whether they have established, the state has established that the text messages and the record of telephone calls was in fact evidence of a crime, given that they don't know what it contains. We'll get to that in just a minute. When it says concealed her romantic relationship with Hemi Newman from the police, a romantic relationship is not a fact. It is in fact an opinion. The word romantic is an adjective used to describe someone's subjective interpretation of how the relationship feels to them. I believe that is probably why the state did not allege that she concealed evidence. They instead alleged improperly that she concealed facts. And I would suggest to Your Honor that that is insufficient and gives another ground why count one is subject to a general demurrer. The last line of the count says that the defendant somehow violated Georgia law by concealing her knowledge of Hemi Newman's culpability in the murder of Russell Sneiderman. Setting aside for a fact the point that the state has not come close to proving whether Andrea Sneiderman had knowledge of Hemi Newman's culpability, the knowledge itself that she had is not evidence of a crime. Evidence, this statute is typically applied, for example, to someone throwing away a pouch of drugs, hiding a gun. In this case, the state has tried to bootstrap the knowledge element. If you notice up above, it says that, actually, sorry, you can't find it in the count. It's in the statute. You can't find it in the count that the defendant had to know or reasonably have reasonable grounds to believe that the defendant had committed a felony. That knowledge is what they are now saying she violated the law by failing to disclose to the state. You cannot bootstrap the statute in this manner. The state is attempting to create some very new and very bad law here, Your Honor, and we respectfully submit that count one is subject to a general demurrer. Would you please move forward, Mr. Williams, to count two? All right, there you go. Actually, you're fine. Go back. Count two. Count two is, this is the statute, 1610-50, concealment of a material fact. Any person who knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device, a material fact, violates the law. The state, would you please move forward to the actual allegation? Well, first, let me talk about those elements briefly. I will do that, and then we'll get to what the state has alleged. The Court of Appeals has made it very clear, and this is based on federal case law largely, that in order to prove a trick, scheme, or device, the state must actually allege and prove that the defendant engaged in an affirmative act of concealment. The Marcus v. State case is a very important case. It was a case from the Georgia Supreme Court. And in that case, the court overruled a denial of a general demurrer, if I'm correct. And I'm not going to represent that to it. I believe that's correct off my memory. But the court made it very clear that silence is insufficient and nondisclosure is insufficient to allege an affirmative act of concealment. The state must allege and prove that there was a trick, scheme, or device, and they must allege that the defendant engaged in specific acts to do that. Can we go to the next slide, please, Mr. Williams? Okay, that's just the statute. The Tesler versus State case is a Court of Appeals case which specifically discusses the requirement that the state prove the defendant concealed a material fact. Next slide, please, Mr. Williams. Count 2. This actually is rather remarkable. The state of Georgia in this count has charged the defendant with a crime for concealing facts from the police. It says concealment of facts within the matter or in matters within the jurisdiction of the Dunwoody Police Department. It is not a crime to conceal facts from the police in this country. One must actually engage in a trick, scheme, or device to conceal a material fact. This indictment does not reference the trick, scheme, or device, that language, an element that the Supreme Court stated in the Marcus case is a required element of the offense. Second basis for the general demurrer is that count 2 does not allege materiality. The word material appears nowhere in the indictment. And the grand jury very well could have believed that Mrs. Sneiderman could have violated law by concealing a fact rather than a material fact. That is not in the indictment. In addition, as we said before, and this comes up an awful lot, Your Honor, because the state has attempted to rely very heavily on their case to put Mrs. Sneiderman in prison on the definition of romantic. This argument comes up quite a lot. I'm afraid I'm going to have to repeat it a couple times. Look at what it is that is alleged to have been concealed. The existence of a romantic relationship. Now, Your Honor, I've been married for a long time. I have been with my wife for 25 years. I'm still not sure I understand exactly how she defines the word romantic. There have been times when I thought I did a good job and apparently I did not. That is not a fact. That is an opinion, and it is not a material fact that would support this count. In addition, Your Honor, under federal case law, and let me take a step back because I'm going to explain why federal case law is relevant. In federal case law, the courts have interpreted 18 U.S.C. 1001. That is the federal concealment and false statements statute. The Georgia Supreme Court has made it very clear, including in the excellent opinion by Justice Namias in the Haley case a couple years ago, that Georgia's false statement and concealment statute should be interpreted by referring to the federal cases interpreting the federal statute. The Georgia courts haven't really had a lot of cases involving concealment. Under the federal law, though, the overwhelming majority of federal circuit courts of appeals have concluded that in order to convict someone for concealing a material fact, there must be a legal duty to disclose that fact before it can be form the basis for a crime. Our brief, Your Honor, at page 11 provides a number of citations to federal appellate court decisions holding that. I will not recite all those to you in the interest of saving time. We respectfully submit that the Georgia statute must be construed consistent with the federal statute, that there must be a duty to disclose before the defendant can be charged with concealing something from the police. The next ground, Your Honor, is a failure to allege that the Dunwoody Police Department is a government department or agency. And I know that may sound a little bit facetious, but statutes are to be strictly construed. The definition of department and agency is something that may or may not be something the grand jury found in this case, because it is not alleged in count 2 that the Dunwoody Police Department is a department of a government agency to the extent required by the statute. Again, Henderson versus Hames, Supreme Court 2010 unanimous decision. All elements must be pled. Your Honor, I'll now move on to the false statement counts. And I think you can just turn the PowerPoint off at this point, Mr. Williams. The false statement counts allege a violation of the same statute as the concealment count. It alleges the statute allows charges to be brought on the basis of different facts or different acts. One is concealment, the other is making a false statement. In Haley, the court identified 3 elements to a false statement charge. First, the defendant must knowingly and willfully make a false statement. Second, the statement must be in a matter within the jurisdiction of a department, agency of state government or the government of any county, city, or other political subdivision. Third, effectively, the defendant must willfully and knowingly make that statement, knowing that it's in the jurisdiction of the agency. In this particular case, as to these counts, again, the state does not allege that the Dunwoody Police Department is an agency satisfying the definition in the statute. I will not spend a lot of the court's time on that. It's spelled out in our brief. I would point out that they also do not allege in counts 8 and 10 that the defendant knowingly and willfully made a false statement in a matter within the jurisdiction of the Dunwoody Police Department. Counts 3 and 5 do include that language, which suggests that the state was aware that it needed to use it. They did not do that in counts 8 and 10. Your Honor, we are also asserting a constitutional argument, and before I make this argument, I want to make sure I'm very clear with the court. The argument that we're about to make very briefly has been rejected by the Georgia Supreme Court indirectly. The Georgia Supreme Court has held in a number of cases that because the Georgia statute does not include a materiality element, the false statement allegedly made by the defendant does not have to concern a material fact. They have held that in the Banta case. It was referenced in the Haley case. I want to make very clear that we're not arguing that the court has the discretion to overturn that law. However, in the Haley case, again, the opinion by Justice Namias referenced the fact that the Georgia false statement statute is premised upon the federal statute. There was a clause in that opinion that specifically said that because the last time the Georgia statute was amended was in 1979, pre-1979 cases interpreting the federal statute are instructive interpreting the Georgia statute. Those cases, largely for constitutional reasons and to prevent the statute from being overbroad, incorporated a materiality element into the federal false statement statute. They basically said that in order for the statute to be valid, it had to be restricted so that it was only a crime to make a false statement about a material fact. In the late 1990s, Congress, basically following that line of cases, amended the federal false statement statute. It now expressly includes a material fact requirement. It is not a crime under federal law to make a false statement to a government agency about a fact that is not material. We respectfully submit to Your Honor that that must be the law in Georgia as well. I want to make it very clear, as I have before, that you are probably bound by the existing decisions of the Supreme Court. If necessary, we wish to raise that argument for a good faith argument for the extension or overturning of existing law.
Thank you very much.
Your Honor, that's all I have on the general demurrer. Happy to let the state respond if you want, or I can move on into the directed verdict for acquittal.
Well, before we get to that, let me hear from the state.
Thank you, Your Honor.
And I know you had said at the bench conference you had not gotten a copy of his brief. Are you ready to proceed?
I'm willing to go forward, Your Honor, but I haven't read through all 30 pages or so of the defense brief. I think I am prepared to respond. At this point, Your Honor, the court is well aware about the standard that is required to establish the sufficiency of an indictment for a general demurrer, and the true test, again, isn't whether it be more definite, more precise. It is whether it contains the elements of the offense charged and sufficiently informs the defendant of the charges so that she can present her defense without being surprised by the evidence. It's a notice provision. It's a notice provision. I'm going to hand the court two cases, if I may.
Oh, you may.
Thank you. Hardridge, Harridge versus the state. It's a 243 Georgia Appeals, 658. It's a 2000 decision. Also Carey, C-A-R-E-Y versus the state. It's a 263 Georgia Appeals, 109. It's a 2003 decision.
263 Georgia Court of Appeals, 109.
carry is 109, Your Honor, yes.
Your Honor, we respectfully request copies if they're available.
I don't have an extra copy, Mr.
Chalmers.
Mr. Chalmers, thank you. So I have to bring you one in the morning. May I approach?
Copies will be provided. Thank you. You may approach.
The defendant's argument that the count 1 in particular, actually I believe it was the same argument as the count 2, is missing a reference to as opposed to the elements of the statute as described. I'll just note for the court and for Mr. Chalmers that the language of the indictment references the statute in question, and any deficiency or any failure to state with exactitude all of the language of the statute can be cured by a citation to the statute, and that's in fact what the state did. Any willful and intentional language is referenced by the statute that surely put the defendant on notice of what she is charged with, what she needed to defend against, and protects her from a double jeopardy claim in the future. So we ask the court just to acknowledge and follow that portion of the law, that a recitation to the statute as was present in every one of the state's indicted counts would cure the issue that Mr. Chalmers raises as far as any absence of the word material or absence of any intent language. Mr. Chalmers then moved on to talk about facts. Facts are not evidence. Facts are not evidence. And facts are indeed evidence. That there is no distinction between the word fact and the word evidence for purposes of a general demurrer. That state alleged that Ms. Sneiderman withheld and concealed facts. That's an affirmative act. She told the police one thing when in fact the truth was something else. She did so with the intent to mislead. All of the evidence presented to this jury to date would support the state's indicted language and support the substance of the charge, that she did in fact hinder the apprehension of a criminal, that she concealed material facts, she concealed facts about her relationship with Mr. Newman. It was an affirmative act, not just omitting information. She affirmatively misled the Dunwoody Police Department during the course of the investigation. And that testimony, taken in the light most favorable to the state at this point, is sufficient to withstand the defense directed verdict motion. I also want to identify, Your Honor, I appreciate Mr. Chalmers' candor in referencing the court to the opposing authority as far as the constitutional argument about the materiality of the facts during the course of the investigation. That is, in fact, not the state of the law, and Georgia wouldn't support their position. So I appreciate his candor in bringing that to the attention of the court. There is no constitutional violation in the way the statute as written or as applied to Ms. Sneiderman that would result in a directed verdict. And finally, much of the argument advanced by the defense, as I understood it, is wrapped up in or is an interpretation of the word romantic. We disagree or dislike or see deficiency in the use of the word romantic. I will refer the court to remind the court of the testimony through some email exchanges that were introduced into evidence and read aloud to the court. Romantic is the defendant's language. Romantic is Henry Newman's language. They wrote a series of emails to each other that reference the word romantic. Romantic is a word of common use and understanding, and it is not beyond the ken of this jury to interpret and understand what romantic means, but beyond that, it is in fact the defendant's own words and Mr. Newman's own words that reference romantic and describe gestures between them as romantic. So that is not a stretch. That is, in fact, the evidence. And it was Ms. Sneiderman's denial of a romantic relationship that resulted in a perjury count, at least one of the perjury counts against her. I believe I've referenced most of Mr. Chalmers' points as he has argued them. I'm happy to address any. I'm happy to address any question or concern of the court, but I would like an opportunity to read Mr. Chalmers' motion just to make sure the state's argument and response is complete.
Well, I may give you that opportunity. The issue of the Dunwoody Police Department not being an agency of a political subdivision, you want to address that issue?
I will. I'll make two arguments in response to your honor. One, I don't believe that that is a necessary element of the offense. The offense as it is charged identifies the Dunwoody Police Department. And number two, and the defense has cited no law suggesting that that is anything other than the agency, a geopolitical agency. But finally, in addition, The cases I gave the court cite to refer to the fact that any omitted language in the indictment, even if it is part of the element, is cured by a citation to the code section in question. Certainly there is no, again, we're talking about a notice. There's no, I think, reasonable way that the defendant could argue that she was not on notice that the Dunwoody Police Department is anything other than a geopolitical subdivision as referenced by that statute. If they were confused, she need only to reference the statute as it was cited in the count. The Carey case and the Harvard case would support that state's position that that was in fact the term and the responsibility of the Dunwoody Police Department, and so it is cured by the citation to the code section. If there was an error, I don't believe there was an error, but if it was cured by citation to the code section.
All right, thank you.
Thank you.
Mr. Chalmers?
Yes, sir. Your Honor, I have a copy here for you of the case Dixon versus State with the relevant section tab. You approach, Your Honor?
You may. Yes, sir. Thank you.
Your Honor, the state's first argument in response on the general demurrer that although they don't believe that the indictment was defective, without stating any reason why those elements that were missing were in fact alleged, the state has basically relied on a line of cases which is no longer good law in the state of Georgia. There are a series of cases over the years which basically state that if if the state includes the language in violation of a specific statute, the elements of that statute are incorporated by reference into the indictment. In Henderson v. Hames, and Mr. Williams, would you mind putting up the PowerPoint? That's not the right slide, Your Honor, so we'll go ahead and move forward if you would, Mr. Williams. Okay, there we go.
Yes,
next one, please. Next one, please. Okay. Your Honor, this is the statutory language that was spelled out in the criminal charge in Henderson. And I want to remind the Court we're talking about a unanimous opinion of the Georgia Supreme Court.
Yes, sir.
That statute specifically spells out two components. And the text you were reading, Your Honor, is actually from the opinion. OCGA 1611-108A spells out the two components of the mens rea necessary to violate the statute. And you can see that we highlighted them in 1 and 2. There were two separate elements of intent that the state was obligated to allege and prove. Would you please move forward, Mr. Williams? The indictment in Henderson, in count 5, charged Mr. Hames with the felony misuse of hunting equipment in that he did, etc., 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 and the very end, in violation of OCGA 1611-108. The indictment in the Hames case very clearly incorporated that statute. Next slide, please, sir. The conclusion of the unanimous Supreme Court based on that indictment was that the indictment thus omitted entirely any reference to the statutory requirement that Hames consciously disregarded substantial and justifiable risk. In other words, the Supreme Court unanimously concluded that an indictment that included the in violation of language was insufficient, and they ruled in favor of the defendant and that the indictment and the convictions are void. I would also bring your attention, Your Honor, to the special concurrence by then Judge and now Justice Keith Blackwell in the Dixon case. The citation is, for the record, 313 Georgia Appellate 379. It was decided on November 23rd, 2011. In that case, Judge and now Justice Blackwell said as follows. In Division 2, the majority says that the indictment sufficiently charged a violation of the statute, even though the indictment does not mention things that are, Dixon says, essential elements of a violation, because the indictment alleges explicitly that Dixon acted in violation of the code. The latter allegation saves the indictment, the majority explains, because an allegation that the accused violated a statute necessarily alleges every element of a violation of the statute. Although several prior decisions of this court have endorsed that principle, I have doubts about the soundness of the principle. The very next paragraph, the Justice Blackwell, then Judge, discussed Henderson v. Hames. It's pointed out that in the Hames case, the indictment specifically used the language in violation of. Notwithstanding that, the court concluded that an indictment is void to the extent that it fails to allege all the essential elements of the crime or crimes charged, and concluded that the indictment omitted an essential element of a violation of the statute. For that reason, the indictment was defective. And this is from Judge Blackwell. In light of Hames, the principle on which the majority relies today seems doubtful. I think that the state is attempting to remedy its defective indictment in this case by incorporating a principle of law that was rejected by a unanimous Supreme Court 3 years ago and then perhaps slightly resurrected or attempted to be resurrected by 2 judges of a 3-judge panel of the Court of Appeals. I would respectfully suggest that in light of Henderson v. Hames, the state must clearly allege and prove all the elements of the offense, which they have failed to do. The state, in its argument, also said, with respect to the concealment count 2, they claim that the defendant told the police one thing and thereby concealed. An allegation that someone told something to the police that was a concealment is an allegation of a false statement. There is a separate prong of the statute that is applicable to false statements. They did not allege in count 2 a false statement. They alleged concealment by a trick, scheme, or device. The state has also not, in its argument, identified any such trick, scheme, or device other than an alleged misleading statement. That is insufficient. The statutes, excuse me, Your Honor, the cases that talk about tricks and schemes and device are relatively few, but they talk about agreements between the defendant and third parties to lie. We're going to have a scheme where basically we're going to agree to tell our stories be the exact same thing, then go into the police and tell it that way. In this case, there's no such scheme, there's no such trick, there's no such device even alleged. With respect to the argument that Mrs. Cross made about the fact that the evidence showed that the defendant effectively or affirmatively misled, I believe that's an argument more appropriately directed for our motion for directed verdict, and I will save for that. And then finally, the state argued that with respect to the question that Your Honor asked about the agency and department of a government, whether or not that's an element of the offense, they claim that that is not an element of the offense. I would respectfully refer the court to the Haley decision again from the Supreme Court, which laid out 3 elements of an offense of that statute. And not only was alleging and proving that the agency was in fact a government agency an essential element, the court added an additional element to make sure that the defendant knowingly and willfully made a statement knowing that it would get to that government agency. The government agency issue is in fact an essential element of this offense. It was not alleged in these counts. Thank you, Your Honor. I can move right on to the motion for
although I know because I know she's in the process of reviewing some of your written documentation, so I'm going to give her an opportunity to see if she wants to add anything else, and I will come back to you, Mr. Chalmers, because you will have the last word. Anything else from the state?
Only something may I approach for a moment, Your Honor?
You mean the lawyer? Yeah.
Yes,
Oh, sure.
Lord.
Yeah. Come on up, lawyer. No, come on up. You got time. Come on up.
Tell me when. I'm Jeff Hellinger, back with Attorney Tom Beaver. And Tom, we're seeing the attorneys right now in front of the judge. The jury is out of the room. State concludes its evidence. The defense begins tomorrow. They can either bring evidence or they can elect to play their hand, meaning they don't have to call anybody.
Right. It's a little. I was a little surprised that the state rested its case so abruptly, but that means that they cannot bring any further evidence in.
All right.
And now it's the defense's turn. They're hearing motions now to dismiss, which is standard at the end of the state's case.
All right, let's go back to Judge Gregory A. Adams.